Okay. All right, good afternoon, students, and good afternoon, Dr. Abdul Bassett. Students, as I told you, that we are going to have a Q&A interactive session with my colleague, Dr. Bassett. And I'd like to place a record that not only me will be committed to helping students, but Dr. Bassett last year, I remember that he came around the same time to have this kind of session with us. So Dr. Bassett, thank you very much for your selflessness and also commitment to help students. And as I said, this one is not only for our students. We are not doing this only for students. We're doing it for all students who are going to write the entrance examination. But let me announce some housekeeping. I noticed that some of you, please, you have you've not muted yourselves. You are getting the feedback from your end. So unless you are invited to speak, all the time your mic should be off so that we don't get the feedback to just the quality of the sound, please. Thank you very much. Yeah, so this afternoon, as we indicated, we will be having conversation around constitutional law and criminal law. At this stage, we know that all students have been working very hard in order to get ready for Friday. So this is not really a lecture session, so to speak. It is just to help clarify maybe some few things that you are not clear about. And so, for that matter, I would like Dr. Bassett. Dr. Bassett, if you can let us know if you're online. So you are welcome before we start.
Thank you so much, Ernest. It's a pleasure to be joining this view class for the second time in it's always a pleasure to interact with students, and thanks so much for putting it together.
And this for the last two.
Dr. Bassett, yeah, thank you very much. So maybe putting myself in the shoes of the students who are writing on Friday, maybe I'll start from constitutional law, so that speaking on behalf of most of the students, and we do this for a few minutes before we later on allow the students to bring up their own question. And we are doing this so that what we'll be doing will be reflecting maybe questions that a good number of you may have. So that at the end of this Q&A conversation with Dr. Bassett, if there are still some issues which we haven't raised, still, but you can raise those questions. So those who are raising your hand, it's not time for you to be brought in. So just be patient. So Dr. Bassett, constitutionalism, as a student preparing for this law school entrance examination, what will you suggest that I remember about constitutionalism?
Yeah. Okay, thank you so much, Ernest. Yes, any student preparing to take a constitutional law exams should know certain peculiar topics in constitutional law. And one of these topics is constitutionalism. Constitutionalism is one of the key topics in constitutional law, because students will recall that constitutionalism is actually an aspect of the rule of law. So in constitutional law, when we talk about rule of law, generally, apart from A.V. Dicey's conceptions about rule of law. The main thing about rule of law is that you are governed by rules, and the rules should be limited to some extent, such that those who are exercising power do not act capriciously and arbitrarily. And one of the concepts that promotes the rule of law is constitutionalism. Now, constitutionalism, as you all know, is essentially a doctrine, a concept that talks about limitations on the exercise of the powers of government. So when in your constitution, you see that the main organs of government, the legislature, the executive and the judicial, have certain restrictions, have certain limitations on the exercise of their power, then we're talking about constitutionalism. And as you all know, there are essentially three main forms of constitutionalism, right? We have what we call substantive limitations, right? We have procedural limitations, and then we also have institutional limitations. Now, in addition to these three elements or types of constitutionalism, it's also important for us to know the conditions that make it possible for a country to have constitutionalism. Right. So to answer your question, to answer your question directly, a student who is preparing for constitutional, or particularly in relation to constitutionalism, must know one, what is constitutionalism? It is essentially limitations or restrictions on the powers of the exercise of government. Two, the student should know the types of constitutionalism, the types of limitations or restrictions. And here we talk about three main types: the substantive limitations, the procedural limitations, as well as the institutional limitations. Three, the student should also know the conditions, the elements that make it possible for us to have constitutionalism. Then the fourth point that the student should bear in mind is that the fact that you have a constitutional government doesn't mean that you have constitutionalism. You can have a government based on constitution, but if the constitution doesn't have these types of limitations, or if the conditions that make for the practice of constitutionalism do not exist in a particular constitution, we'll still say that that particular constitution doesn't really entail the concept of constitutionalism. So to answer your question directly, in a very in a brief manner, these are the four things that students should pay particular attention to. But if students want us to go a bit more into detail in terms of the various types of limitations, we could do that. But for now, these four key points should be borne in mind in terms of questions on constitution.
Right. Thank you, Dr. Bassett. Now, if I needed to get maybe examples of decided cases reflecting constitutionalism, which ones will you direct me to?
Yes, so when it comes to authorities, both provisions of the Constitution and as well as decided cases of precedent, there are quite a number of authorities that deal with the various types of constitutionality, or various types of limitations on the exercise of the powers of government. Fortunately for us, almost all the major cases in constitutional law, in Ghanaian constitutional law, in one way or the other, relate to constitutional law in one way or the other. So all you need to do, and especially when it comes to constitutional law questions, is that there are certain cases that you must always have at your fingertips. The ratio in these cases cover quite a number of concepts in constitutional law. Of course, the famous one is to fall and an attorney general. So to fall attorney general reflects constitutionalism in the sense that the legislature has certain restrictions. They could not interview justice. They could not let Justice Appalu for the position of Chief Justice because by the constitutional arrangement, his position as CJ was already secured by the whole vetting of Justice Appalu by Parliament. This is the third Republican Parliament, and then their refusal to nominate or appoint him as CJ was basically unconstitutional because there was a certain limitation as to whether or not they could vet him. Now, apart from Tufo, the other case, of course, is also J.H. Mensah. So you remember the J.H. Mensah case. These are quite famous cases. The one about whether or not ministers who have been retained, have to be revetted. They have to. Let me use that exact word that the Constitution used, whether they need a prior approval of Parliament or they need a prior approval of Parliament. And the Supreme Court was very clear that they needed a prior approval of Parliament. So this whole idea that there's no need for prior approval if you have previously served as a minister would not fly. So that is also a limitation on the powers of the legislature. The legislature also here, the executive in particular. We can also talk about the recent case of Justice Abdullahi, the one regarding the casting votes in Parliament, right? So what the Supreme Court did, the judgment, the opinion read by Justice Kolende is basically to say that Parliament, you have limitations. You don't have extensive, untrammeled powers to do as you please. So almost all the major constitutional law cases deal with constitutionalism. And then, of course, when it comes to the constitutional provisions, one provision, I don't remember exactly the article, is the one that says that Ghana, the legislature doesn't have the authority to make Ghana a one-party state.
One-party state, yeah.
One party. Now, that is an example of a substantive limitation. Parliament doesn't have the authority. Now, we have various provisions in the Constitution where one organ of government cannot do something without the involvement of the other. One, it has to do with the prior approval of ministers. One has to do with the consideration of justice of the Supreme Court by the legislature, and so on and so on. So all these are examples of limitations, either in the Constitution itself or in the cases that I just know. There are many other cases that deal with issues of constitutionalism.
Yeah, so thank you, Dr. Bassett. So we could say that even where you are hard pressed, and you remember any of the cases relating to application and enforcement of the Constitution, in a sense, they also reflect an aspect of constitutionalism.
Absolutely.
That? Yeah.
Absolutely. In fact, a lot of the cases on the enforcement of the Constitution where the plaintiff is seeking declaration that certain conduct or certain acts, certain omissions are unconstitutional. Often, the key point is that the person has exceeded his or her authority. In such cases, would be good examples of cases that typify or exemplify aspects of constitutionalism.
Yes. Okay. Thank you, Dr. Bassett. Doc, let me ask this question. Must the enforcement of the Constitution in terms of Article 2, must it be only at the instance of a Ghanaian, only at the instance of a natural person, or it can also be at the instance of a non-Ghanaian and also a non-natural person? What is your take?
No, this is a very interesting question. It's a very interesting question because the clear language of Article 2 of the Constitution does not appear to be consistent with the authorities, with the decided cases that we have from the Supreme Court. So when you take Article 2 of our Constitution, which is on the enforcement of the Constitution, it talks about a person, right? It talks about a person. Of course, we know that under the Interpretation Act, generally, a person refers to a legal person. So it could be a natural person or it could be an artificial person. So as a general rule, anytime you see a person in any statute, including the Constitution, then it is being used in the sense of a natural person or a legal artificial person, right? Corporate entity. However, despite the clear language of Article 2, our Supreme Court has said in quite a number of cases that person in the context of Article 2 refers to a Ghanaian. So even though the article talks about a person, when you look at all the major cases, whether it is NPP against AG, particularly NPP against AG, the one about the one about the protests and all, and also the SIVA case. The Supreme Court has made it very, very clear that person in the context of Article 2 refers to a Ghanaian. A Ghanaian here can be a Ghanaian as a Ghanaian citizen or a corporate entity that is registered in Ghana. So to answer the question directly, it will appear that despite the general meaning of a person in Article 2 of our Constitution, the decided cases have taken the view or have held or have settled the point that person in this context refers to a legal person, that is, the person should be a Ghanaian, either a Ghanaian citizen or a corporate entity. Ernest?
All right, thank you very much, Dr. Bassa. I think that's clarified. Now, this concept, separation of powers, as a student preparing for these exams on Friday, what will you suggest that I address my mind to as far as separation of powers is concerned?
Yeah. Thank you, Ernest. So for under separation of powers, yes, students, one should know what is separation of powers. They should also know that separation of powers is an aspect of the rule of law. It's also an aspect of constitutionalism. Actually, one of the conditions for the existence of constitutionalism is separation of powers, judicial review, protection of human rights, and so on and so forth. So while separation of powers is an aspect of rule of law, it is also one of the conditions of constitutionalism. So students should know what separation of powers is, the doctrine of separation of powers, what it is. They should know a bit about the history. Montesquieu, what Montesquieu said about separation of powers. Again, they should know that SOP relates to the three main organs of government: executive, the legislature, and the judiciary. They should also bear in mind that essentially there are two main types of separation of powers. We have what is called the flexible approach. The flexible approach is where you have certain institutional coordination and collaboration between the organs of government. So the organs of government exercise power, but they may do so in a very collaborative manner. Then you have the strict separation of powers where the judicial power is vested solely in the judiciary, no entity exclusively in the judiciary. Legislative power is solely vested in the legislature, and then you have executive power vested in the executive. And you hardly have any overlaps in the functions of the three organs of government. But in the flexible type, you may see some kind of collaboration. And let me give you an example. When you take our Constitution, when it comes to the prior approval of ministers, for example, it is a collaborative because the executive will do the nomination and then parliament will be involved in the prior approval. So this is where one institution is performing a function, but other institution also has a role. And we have quite a number of these provisions in our Constitution. Right. So apart from knowing the history of separation of powers, what separation of powers is about, and also, I mean, the conditions that also make for separation of powers. One thing that you should pay attention to, particularly because of some recent cases, is the political doctrine question.
Right.
The political doctrine question
was
is an aspect.
It's good you started, yes.
So the political doctrine question is an aspect of the separation of power. It's actually an effect of the separation of powers, and is seen to be an irresistible ramification of separation, of the concept of separation of powers. Sometimes you hear people say that the doctrine, the political question doctrine is not part of our laws, right? Well, it depends on how you present it. The cases that our courts have dealt with so far, sometimes they give very conflicting signals as to whether or not the political doctrine question is part of our constitutional law. But when you carefully consider the ratio of these cases, yes, the political doctrine question is part of our constitutional law, because separation of powers is also part of our constitutional law. Just that there are certain aspects of the political doctrine question that our courts have rejected. Now, what do we mean by the political doctrine question? It basically means that certain matters have been exclusively reserved for certain organs of government, and by reason of that, other organs should not interfere, particularly the judiciary. And for that reason, that matter is not justiciable, right? For that reason, the judiciary should not interfere in those matters. That is the general concept of the political doctrine question. But what aspects of the political doctrine question, which is an American concept, apply in our constitutional law? Well, it's not every aspect of the political doctrine question that applies in our constitutional law. So where you are saying, for example, that a matter has been reserved exclusively to a particular branch, our Supreme Court has upheld that, right? So when you take the J.H. Mensah doctrine, for example, the J.H. Mensah decision, for example, when the Supreme Court said that, look, prior is a matter for Parliament to decide. Parliament has to determine what is meant by prior approval. Prior approval doesn't mean vetting. The Supreme Court is essentially applying the political doctrine question. But what the Supreme Court has rejected, a number of cases, is where a clear matter, which is not reserved, exclusively to an organ of government, is presented as a political doctrine question. In those cases, the Supreme Court has come out clearly, in fact, to say that no, because every article is in our Constitution is justiciable, of course, subject to the learning that we know about the directive principle of state policy. Once an article is violated, it is justiciable. The matter can be brought to the Supreme Court for enforcement. It is only when the Supreme Court takes a view that, oh, this matter has been reserved for a particular organ, and that it doesn't implicate other provisions of the Constitution. That is when it will apply the political doctrine question. So you remember the recent case of Justice Abdullahi, where Justice Yoni Kolendi was talking about the political justice, the political question doctrine. There is language in that opinion that gives the impression that it doesn't apply, but I think that language is too broad. The way I think you should read that opinion is that, look, despite our recognition of the political doctrine question, where it is very, very clear that the constitutional provision is being violated, then you cannot use the political doctrine doctrine as a defense for your violation.
But Dr. Bassett, what about the school of thought which says that this political doctrine question developed against a certain backdrop, and we all know the events regarding Marbury and Madison, the creative assertion of the power of judicial review and all that, and how the Supreme Court of the US wanted to avoid the backlash between the courts and also the other organs of government. So they had to discipline the use of this not explicitly conferred power of judicial review to make pronouncement over constitutionality of things and all that by evolving this political question doctrine. And if you look at our Constitution, the various reports, the Committee of Experts, Constitutional Assembly reports, and all that, are we not really trying to import things which are absolutely not essential to create unnecessary strictures on how our Supreme Court is supposed to make use of the powers which have been given to it regarding pronouncing constitutionality and other things? What do you think?
Yeah, it's a controversial matter, and as you pointed out, even in the US, where the political doctrine question originated, there are issues. There are very serious issues. There are scholars who still cannot accept the fact that the Supreme Court will take upon itself to be pronouncing upon the constitutionality of legislation or acts of Congress. So it is a controversial matter. However, there are certain aspects of the political doctrine question that appear to be less controversial, right? They appear not to be in dispute. They appear not to be in controversy, but other aspects are. And one aspect which is not in controversy is the aspect that, as a matter of constitutional design, certain powers are given to particular organs of government, and those organs of government should be given the latitude, the freedom to exercise their mandate without any interference by any other organ. So when you look at political doctrine question in terms of its very limited scope, then there's nothing wrong with that. A very good example, for example, is foreign affairs. So when it comes to foreign affairs, for example, it is for the executive. The judiciary should not be telling our president how to conduct foreign affairs, who should be the friends of Ghana, whether the US, Russia, Ukraine, or Canada. That is for the executive, right? So despite the controversy regarding the political question doctrine, certain core aspects of that doctrine, particularly the aspect that says that certain matters are reserved for particular organs, and by reason of that, other organs should be interfered. I think has some legal salience in our constitutional law, and those matters are not in controversy.
Right.
Like other aspects of political doctrine question, when the legislature or the executive is using that doctrine as a basis to avoid the accountability or transparency. That's when our Supreme Court, for example, has come in to say that, look, to the extent that what you are saying really is not a political doctrine question, it's not applicable because it violates specific constitutional provisions.
All right. Thank you, Dr. Bassett. So in relation to that, maybe let me bring this recurring issue on the justiciability or otherwise of the directive principle of state policy. What should we remember?
So regarding the justiciability directive principle of state policy, it's important that we know the history of Chapter 6, the directive principle of state policy. The framers of the Constitution were quite clear that those press directives should not be justiciable. They were quite clear that those directives should not be justiciable. However, the very first opportunity, and this is actually in line with what pertains in other countries. In many countries, the principle of state policy are not justiciable. They are basically seen some lofty ideas or aspirations that the executive or organs of government and all those exercise powers of government should try to meet. And often they are cast in such generic language that they lack the specificity, which is a requirement for legal enforcement. So the general view, the directive principle of state policy are not justiciable. However, in the SIBA case, the MPP Attorney General, the SIBA case, our Supreme Court took a balanced position. Let me say the majority of
Doc, let me make this announcement. Students, we know our Zoom account is 300. I know a number of students would like to join, so you can tell them that they can just go on Facebook. They can go to maybe like, and it's also on Facebook. I'm streaming it live over there. And they can follow the same thing through them, since they cannot get in because we've exhausted the account. Thank you. Doc, please continue.
Yeah. So in the SIBA case, the majority view was that, yes, they are generally not justiciable. The only time that they will be justiciable is that if they are linked to specific provisions in other parts of the Constitution that are taken together, they will become justiciable. So without they having counterpart provisions in other parts of the Constitution, particularly Chapter 5, that are clear enough and that are justiciable, the directive principle of state policy were not justiciable. Of course, there was a dissent. I remember that Sadado was quite clear that every provision of the Constitution is justiciable. And so for that reason, the directive principle of state policy were justiciable. But that is the certain position in the Silva case is that they are not justiciable unless, of course, they are linked to other provisions of the Constitution, so that together they will be justiciable. Now, this position has been reversed. This position was reversed in the Ghana Lotteries case. The Ghana Lotteries case, the seminal judgment of Justice Zachaban, he made it very, very clear that, look, we are departing from the position in the Silva case. The new position is that you start with a presumption of justiciability. In other words, start on the basis that the principle of state policy are justiciable. You know, it is only if you realize from the language that it is not capable of enforcement, that is when you won't give effect to them. So the position now is that there's a presumption, they are presumptively justiciable, but you can rebut this presumption if you can show that from the language of the directive, it is not capable of enforcement because it lacks specificity.
Right.
But apart from the reason given in the Ghana Lotteries case for the non-justiciability of the directive principle of state policy, generally in constitutional law, one reason that the directive principle of state policy are not justiciable is that they are often cast in very general language. And because they are cast in general language, they lack that specificity that we require for legal enforcement, right? And because of that, we often use the expression that they are not administrable. When you say something is not administrable, it means that it is so vague that you cannot come out with any convincing legal text or legal principle, you know, for you to enforce it, because you can have so many subjective considerations going into it. And you do not want that. You want the law to be as objective as possible. But if the principles are such that they are so vague, they are so general, it makes it possible for 1,000 views as to what they mean, then perhaps don't give effect to that. That is what is meant by, they are not generally administrable. But as I said, the current position of the law is that you start with a presumption of justiciability, except that when you look at the language and realize that it is too vague, it lacks specificity, then of course, that presumption may be rebutted. One thing I think students should look at is try to compare and contrast the decision in the Ghana Lotteries case and the Silva case. Find out whether, as a matter of fact, in substance and in essence, whether the two decisions are different. Are the two decisions the same in terms of substance, or the Ghana Lotteries case has introduced another layer of complexity in the analysis of the directive principle of state policy. So try to compare the two cases on your own and your perspective.
Yeah, so Dr. Bassett, it will be right then to say that the current understanding on the issue of justiciability of the directive principle of state policy is that the general rule is that it is justiciable. However, you can make a case to show that due to the peculiar nature of the particular directive principle of state policy, it is not justiciable. Would that be correct?
That is correct. So the general rule is that you start with a presumption of justiciability. Okay. You cannot just say that it's not justiciable, just say that it is generally justiciable. Okay. And you rebut that presumption by saying that, oh, the language of this directive is so vague that it is not possible of being legally enforced. So by reason of that, that presumption of justiciability has been rebutted. Yes, so you are correct.
Okay, all right. Doc, if you look at the preamble to the Constitution, one concept which is explicitly articulated is the rule of law. So as a student preparing for these exams, what will you say we should remember regarding rule of law as a constitutional law concept, and also how it is reflected in the 1992 Constitution? You give some few thoughts on that.
So I'll be very brief. So first, rule of law. Know what rule of law is. So the whole idea is that we should be governed by laws, we shouldn't be governed by men, and that there should be certain limitations on the exercise of the powers of government. Know a bit about the history of the rule of law, particularly Dicey's conception of the rule of law, and then also know about new modern concepts, ideas about the rule of law, know about the conditions that make it possible for us to have a rule of law, constitutionalism, separation of powers, judicial review, protection of fundamental human rights, SOP, and so on and so forth. And then the cases, also find cases, be able to remember cases that deal with aspects of the rule of law. The good thing is that all the cases that deal with constitutionalism, they also have to do with the rule of law. Cases that deal with judicial review, in a sense, have to do with rule of law. Cases that deal with separation of powers, in a sense, also have to do with rule of law. So if you don't remember any case at all, the rule of law, nothing prevents you from borrowing cases from constitutionalism, judicial review, SOP, and so on and so forth. NS?
All right, thank you, Doc. Doc, let's come to judicial independence. Of late, when it comes to appointments and removal of judges, and also a lot of concerns as whether we should amend Article 71, which has only got implication with the conditions of the service of judges and all that. What will you say we should remember about judicial independence?
So when we talk about judicial independence, note that judicial independence is also an aspect of the rule of law, because you need the judiciary to be independent of the legislature, to be independent of the executive, so that the judiciary can serve as a bulwark, as a guardian of the fundamental rights and freedoms of citizens. Right. So judicial independence is a sine qua non to rule of law, constitutionalism, and so on and so forth. Now, judicial independence takes many forms, right? It has many elements. Under our Constitution, justice emanates from the people, right? But it is the judiciary that administers justice. And one aspect of judicial independence is that Article 125 makes it very, very clear that final judicial power rests with the judiciary, right? That's an aspect of judicial independence. It means the executive, neither the executive nor the legislature have final judicial authority. Now, one other aspect of our Constitution that relates to judicial independence has to do with the appointment process of our judges, and also their remuneration, and also their discipline, how judges when it comes to appointment. We know that appointments are done by the president, but on the advice of the Judicial Council for many categories of magistrates and then judges. But then when it comes to Supreme Court justices, apart from the Judicial Council and the president, there's also a rule for the Council of State, and there's also a rule for the legislature. So the appointment process has been done in such a way that you have many institutions being involved. And the hope or the promise is that by having many institutions involved and not just limiting the appointment process, particularly of the Superior Court judges to just the executive, you'll be able to ensure judicial independence. Now, one other aspect has to do with the remuneration, the emoluments of our judges, right? It's also an aspect of judicial independence because, look, without the economic ability, the economic means to be truly independent, you may be independent on paper, but your pockets will betray your independence. So our Constitution has put in place a mechanism for determining the emoluments of our judges and magistrates. For the Superior Court judges, we have Article 71, which requires that a committee be set up. For the other justices, there's a different provision that involves the Judicial Council that involves a committee and so on. So that's also an aspect that promotes judicial independence. There was when it comes to the discipline of judges. Remember that we have constitutional provisions relating to the removal of superior courts of judges, right? And it has been done in such a way that it's been sheltered. It's been sheltered from political interference, either by the executive or the legislature. So these are some of the provisions or some of the mechanisms or institutions in the Constitution that seek to protect judicial independence. And luckily for us, the judiciary is kind of like a self-regulating entity. So there's a code of conduct for magistrates and judges, and the breach of the code could lead to certain consequences and punitive actions. But it has been done in such a way that it is sheltered. It is sheltered from the executive or the legislature. The only time that you have the executive coming in, for example, when it comes to the removal of judicial officers or judges, is when the person has already gone through a process, a decision has been taken, and then to be the president who would then act on the basis of advice or recommendations that have been given to him or her. And I think these arrangements all seek to safeguard the independence of the judiciary.
All right. Thank you, Dr. Bassett. Now, with respect to citizenship, when it comes to being a member of parliament, we've noticed how people who have a dual citizenship have had to lose their seat or have had to be disqualified. In terms of preparing for these exams, and we are also in a period where people are talking about amendments to the Constitution or reform to the Constitution. So, including citizenship and any other matter, what will you advise with respect to what students should probably think through with respect to amending the 1992 Constitution?
Yeah. Okay. So citizenship is a very sensitive issue. In many countries, issues of citizenship are really political, right? And elicit all kinds of emotions and certain. It's quite interesting, particularly in our case, right? Ghanaians are one group of people who like traveling a lot, want to be citizens of other countries. But then when it comes to our citizenship, we tend to be a bit maybe close-minded, if I may put it that way. Now, in preparing for the exam, particularly if you want to focus on citizenship, I think there are some key things that you need to focus on. Then I'll come to the issue of amendments. One is, of course, know what is citizenship. Sometimes a distinction is made between citizenship and nationality, but under our laws, we tend to use the two interchangeably. Now, your best bet is for you to take the Citizenship Act, right? And then try to get the various dates in the Citizenship Act, whether or not you are a citizen, whether by birth or descent. Citizenship by registration is very easy. Citizenship by naturalization is quite easy. All you need to do is that you have a certificate of registration, you have a certificate of naturalization, and then we can prove your citizenship. But when it comes to citizenship by birth or by descent, we need to deal with a certain data information about the person whose citizenship is an issue. And then we have certain dates. So those who were born from 7th January 1980, when the Constitution came into force. And then we have all these other dates. So I suggest that you bear the dates in mind, and then that will help with your analysis. Now, the other point I want you to pay particular attention to has to do with the issue of dual citizenship. You need to remember that generally under our laws, we never allow dual citizenship. When the 1992 Constitution came into force, it was quite clear that generally dual citizenship was out of the question, out of the reach of many Ghanaians. It was only in 1996 when we had the constitutional amendment that our legislature made it possible for a Ghanaian, somebody who is already a Ghanaian, to take on another citizenship. So what it actually means is that if your citizenship is not Ghanaian, you cannot take on a Ghanaian citizenship, right? That citizenship works in such a way that you must be a Ghanaian first, and then you can add American, UK, Canadian citizenship. But you cannot be a Canadian and then add Ghanaian citizenship when you look at the clear language of the Constitution. So let's bear that in mind. Although, I mean, in practice, I don't think that is how those who are administering citizenship laws have looked at it. But from the clear language of the Constitution, you must be a Ghanaian first before you can take on the citizenship. So where, for example, you've already lost your citizenship as a Ghanaian, it might be difficult for you to then become a Ghanaian when your starting point is that you are the citizenship of some other country. Now, pay particular attention to the issue of dual citizenship, particularly in relation to member qualification for member of parliament, because of the Quayson case. Because of the secondary case, if I'm an examiner, maybe I'll try to test your understanding of the rules of dual citizenship as far as qualification for qualification for parliament are concerned. So pay attention to that. Now, there has been this attempt to amend our laws on citizenship, particularly the Constitution, particularly also the provision of dual citizenship, to make it possible for Ghanaians who are dual citizens to be able to occupy certain positions. You remember that when you are a dual citizen, you cannot occupy certain positions. You cannot be president of Ghana, certain high positions. You cannot occupy those positions. And that decision or that position was affirmed in Kweku Asare's case, Asare and the Attorney General. There are so many Asare and Attorney General cases, but this one has to do with citizenship, where the plaintiff was making the claim that the provision, the restriction of dual citizens against holding certain positions was unconstitutional. Unfortunately, the Supreme Court by majority decision affirmed the constitutionality of those restrictions. I think I have seen, I don't know whether it's a private member's bill. I don't think it's been passed yet. That is seeking to amend the provisions of our Citizenship Act to make it possible for dual citizens to be able to occupy certain positions. I don't think it has traveled.
Private members bill, yeah.
Yeah, I don't think that's traveled very far.
No, it's not gone far.
Yes, but this is an attempt to try to remove some of the restrictions so that dual citizens will be able to occupy certain positions that for now they are able to occupy. Ernest?
Okay. Now, just because the amendment is gaining a bit of traction following the public letter by the majority leader, Chairman Sabonsu, and also then his attempt to set up some sort of like a committee of the sort to make some studies into possible proposals for amending the Constitution. Apart from what you have told us, is there any other thing in particular with respect to amendment, and also aware of the Constitutional Review Commission, which you and I had the privilege of being part of, which maybe will allow students to, as part of their general reflection, to also address their mind to sense nobody knows where the question is going to come from?
Yes, Ernest. I think Professor Kweku Asare, his writer, has really covered the bad consequences or effects of some of the restrictions on dual citizens. And I agree with him. As I pointed out in my introductory remarks on this question, Ghanaians, we love to travel a lot. I'll not be surprised in terms of some of our best brains. Sometimes I take the view some of the best brains that we have in Ghana are outside of Ghana. You know, and many of them had to leave because of hard economic circumstances. And they still feel that Ghana is their home. And I do not see why such persons who had to leave in the 70s and 80s and they had to lose their citizenship because of marriage and whatever should be denied opportunity to serve in certain positions because they possess the citizenship or nationality of some other countries. But one thing that I think we should maybe consider in any amendment processes. Of course, there are reasons why for certain positions you would like to restrict them to Ghanaians and Ghanaians only, particularly those sensitive positions that involve issues of national, that may have issues of national secrets, interests, and what have you. You don't want a situation where your president is a Ghanaian and also a US citizen who owes allegiance to the United States government, right? So in the event of war, God forbid, whose allegiance should be upheld, that of Ghana or that of the United States. So there are some of these are concerns. But I think one way you could deal with it is, for some of these maybe sensitive positions, what we could do is we'll allow you, we'll give you the opportunity if you want to occupy those positions before you assume office, for example, for you to renounce citizenship of that other country. If we think that renunciation is important for issues of national security, for example, but to have a very categorical rule that you don't even qualify for that position in the first place, I think is not good enough. It's too draconian, and that we need to find to provide avenues for Ghanaians who have taken on citizenship of other countries and who wish to serve their country to be able to do so regardless of the nature of the position that they wish to do.
Okay, all right. Thank you, Doc. Just before we leave constitutional law and do a bit of criminal law, and then we allow the students to come in, since I know we are all pressed against time. With respect to this LGBTI, which students have actually been anticipating it for quite some time, people point to Article 33 clause 5 of the Constitution as being a window through which there could be a recognition of such a right. And some may also point to the 2010 Constitutional Review Commission report, which said that the issue of LGBTI or the issue of like same-sex marriage should rather be left to be interpreted, by the courts. Olu share some few thoughts to students.
Yes, Ernest. So this is a very topical issue, not only in Ghana but all over the world. It appears the human rights movement has been on this issue for quite a while. There's a great deal of advocacy around this issue. There's also been opposition from other quarters. It's a very ideological, very ideological matter. And you recall that recently a bill was introduced in our own parliament. The defense. What is the short title? Is it defense of the proper family values bill?
Yes, promotion of proper family values and sexual something. Yeah.
Exactly. So a bill was introduced, or an attempt was made to introduce a bill. But from a constitutional perspective, it is important always to emphasize this point. From a constitutional law perspective, I mean, we run a kind of like a liberal state. Our constitution has liberal foundations. So it's a foundation that respects freedom, that respects liberty. The only time that your liberty is restricted is in the exercise of your freedom and liberty is harming the exercise of others' freedom and liberty. So that is the starting point. So once somebody is engaged in conduct that doesn't cause any harm to you, that
Dr. Bassett, are you there? Bassett, are you there? In the same. I think.